SJC-12066, Commonwealth v. Randy A. LeBlanc.
Ms. Powers, good morning.
Good morning. May it please the court. My name is Leslie Powers, and I represent Mr. LeBlanc in the appeal before you today. Before I begin my argument, I'd like to draw the court's attention to an omission in my brief on page 10. I apologize. I reference I say, however, on the second full paragraph, the next three prohibited acts support Mr. LeBlanc's position. I dropped a paragraph, and I'm sorry. I should have been very clear that I'm talking about the next three statutory acts that are referenced within the statute itself, 8M, 12A, and 13B, so I do apologize for that. We are here today on a case of both statutory construction and a question of ambiguity on a specific statute. I don't think there's any dispute on the facts that lead us here today. Mr. LeBlanc was convicted in front of Judge Ross out in the Orange District Court of striking a car in a private parking driveway with his vehicle. There was some testimony that he gave information to the person he thought whose car it was, but there was contrary testimony. That person said, I never got that information. I never told him it was my car. So there was certainly sufficient evidence to satisfy that he left without giving enough information. There was also sufficient evidence to satisfy that he hit the car. The question is, it's a private driveway. So the question becomes, does the particular statute he was charged under, 90 Section 24(2)A, allow a person to be convicted of a property crime of this type in a private driveway? In order to get there, you have to parse the statute. The problem with the statute, there are multiple problems with the statute we're going to talk about, but the bigger problem is there's a real split in non-persuasive authority. You have two cases, you have Platt and you have Velasquez, both in dicta, that indicate that the public way is a necessary condition for a conviction under this part of the statute.
But just to take Platt.
Certainly.
Platt is the case where the car ended up on the lawn, kind
Correct,
of
and
flipped
it was,
over, right?
Correct. And it was,
so
sorry.
I appreciate that there was evidence, I think, of driving on a public way, but certainly the damage to property did not, as in this case, happened on private property, didn't it?
In Platt?
Yeah.
Well, I think the focus of Platt was really the operator, and it's just in dicta.
Maybe the focus, but
Right.
to the extent that it mentions that driving on a public way is an element, I guess I took from it that you couldn't say the case stood for the proposition that the property damage had to happen on a public way, which is, I think, your position, right?
Well, that is my position, yes, correct, Your Honor. And the problem with Platt is that in the footnote, it talks about the elements that are needed, and it does say it needs to be on a public way. I think
Just mentions public way. It doesn't say that does it say that the property damage has to happen on a public way?
it says that in order to be convicted of leaving the scene of property damage, it has to happen on a public way, yes, in the footnote.
But it was an identification issue.
It was an identification
And so they
issue.
really weren't focused on the public way issue.
I don't disagree with you, Justice Lowery, and that's the problem, because then the appeals court in this case, when we went up on appeal, used Platt to talk about, it was a little confusing, but it seemed to be their position was that you could be on a public way before or after, and it didn't really matter, which I don't believe. I think Mr. Townsend and I agree that really didn't address the issue, which is, but do you have to be on a public way in order to be convicted of leaving the scene of property damage? And I think, yes, ma'am.
So is there, the statute uses two different words. In that first clause, it uses operating, and in the clause that refers to your client, it uses the word collision. So the first one clearly uses the word public way.
Correct.
And which would suggest that you have to be operating on a public way. But the second one uses the word collision. And that clause doesn't say one way or the other, private or public. Do you draw anything from the use of those two words as to what the statute requires or what it applies to?
I think, Justice Hines, if I understand your question, I don't know how he could not be operating under this statute. This is under the purview of Section 90, which governs motor vehicles and aircrafts. So I think, looking at that entirety of Chapter 90, you would have to be operating, because otherwise, I believe, and maybe I misunderstood your question, I'm sorry, if I walked up and hit a car with a hammer and left, I could be, but I wasn't driving another car, I would then be subject to being prosecuted under this statute.
I don't have an answer that I'm testing you to see if you have an answer. I'm just trying to figure out if it means anything that they use two different words there.
Well,
That's all.
I understand, Justice Hines. I think that, again, looking at Chapter 90 in its entirety, considering that it governs the use of aircraft and motor vehicles, that they mean to include that it has to be operating.
Now, we have, of course, many whoever's.
We do, and
and-
that's the real nub of the problem, Chief Justice Gant. The beginning seems clear. It has sort of the classic formulation, whoever upon any way or any place of which the public has a right of access, and then it lists a couple of things you can't do, which is drive negligently, drive recklessly, and basically drag race. Then it goes on and it talks about or whoever, and the question becomes, does that or whoever, after that comma, cleave the public way element from this statute and prosecution under the subsequent sections? And our argument is it does not, because if you cleave it, then the rest of the statute doesn't make sense, if I may explain. 17 and 18 talk about speed limits. Now, if you look at the definitions of ways, 17 and 18 actually, and I concede in my brief, sort of cuts to my brother's position, because it says a way. It doesn't say a public way. Under 17 and 18, it says a way. What does that mean? You look in the definition section, it's a little murky, but it seems to be ways that not only are, public ways, but private ways where the citizens have gone, say they own a park, and they say, I'd like to have some sort of speed limit for driving through the park. So those actually help my brother. But if you look at then 8M, 12A, and 13B, if you say the public way has been cleaved from those sections, then you're it makes absolutely no sense at all.
Because public way is used in each one of those.
Because the public way is used for each one, and not only that, there's an actual exception where they talk about, even if you're on a public way, if you're parked over to the side, we won't count that. So public way is certainly agreed in those three, or assumed in those three sections. I think the biggest problem, and it really gets to the ambiguity argument, is these three elements that are sort of stuck in there that talk about you're going to be punished the same way, and that, make no mistake, all of these things have the same punishment. That's kind of the guiding light here. You're going to be punished the same way if you let somebody use your license, you make a false report and to get a registration, or you give false information to get a license or a learner's permit. I've racked my brains trying to make that a public way argument. This is what I've come up with. It's not the strongest argument, I agree. But the only thing I can think of is all three of those sections assume that you're getting a license to use a vehicle on a public way.
So in this large paragraph with lots of whoever's, some have public way elements either expressly, or
Right.
some have public way elements grafted onto sections they cite.
Correct.
And some have no express public way whatsoever.
Exactly, and that's why the argument I can make is the ones that don't have any public way at all, I think you can read into that, you're getting a registration so you can drive your car on a public way. You're giving false information so you can get a license so you can drive your car on a public way, because otherwise it doesn't matter. You can drive your car on your cornfield and, there's you don't need a license for that. The one that's very difficult is letting someone use your license or your ID, or your license or your learner's permit. I think the argument has to be made, you're giving it to them so they can use it on a public way.
Well, I mean, it's not I mean, to your point, right? I don't know enough about learner's permits, but you don't need a license to drive, do you, on private property?
Do not.
So the only place you would need a license or a learner's permit is on a public way,
Correct.
right?
Correct. And that's why I believe that the beginning phrase, upon a public way, actually do apply to those three sections. It's more difficult analysis, but I think they do apply. If I may move on, I'm sorry.
I mean, I know the legislature in 24(2)(a)(5) have
Exactly.
expressly made public way an element where there is injury or death arising from the accident.
Exactly. And I think that supports our position, because they specifically made public way. So if you agree with my brother's analysis of the statute, you could run someone down in a driveway and not be prosecuted, and then leave, not be prosecuted for leaving the scene after personal injury. But if, as you're backing out, you hit the garage, you could be prosecuted for leaving the scene of property damage.
Now,
That doesn't seem to make much sense to me.
in terms of, I think we can all agree upon that, but in terms of the timing of 24(2)(a), I gather was revised? In terms of the timing of the enactment of these statutes or the revision of these statutes, I thought 24(2)(a) had been subsequently revised.
I am not sure about that, Your
Well, didn't it
Chief Justice
originally
Grant.
have public way?
Oh, way back, yes, way back when, and you can look under the cases, and I always
So what
mispronounce
would
them.
be, so
Hofsfeld or
what
something.
inference do we make from the elimination of public way where they actually did revise the statute? And was 24(2)(a)(5) ever revised? I mean, is it simply a matter of the legislature looking at a statute and saying, it really does not make a great deal of sense to require public way for this, so we're not going to do it, and they apparently may not have undergone that analysis because they never took a fresh look at 2(a)(5).
I actually think not, Chief Justice Gantz. I think that this is a situation where the chicken was ground up and stuffed in a pork sausage casing, and it's problematic because I think 24(2)(a), way back when, it was very clear that leaving the scene, it had to be on a public way because you had to protect the public. And then it went through these permutations, and then we have these things stuck in here. But I think that the fact that 24(2)(a)(5) specifically says public way, again, supports that you need a public way under 24(2)(a), because again, if you don't, it's a crime to leave property damage in a private driveway, but it's not a crime to hit somebody in a private driveway and be charged under this statute. Maybe there are other statutes, but under this statute.
But if that's the case, why shouldn't we say 24(2)(a) does not require it, and the legislature should take a fresh look at 24(2)(a)(5), because it makes no sense that if you hit, as you point out,
Right.
if you crash into a house
Right.
and don't give your name, you can be prosecuted. But if you crash into a house and injure somebody who's in the house,
Right.
then you can't be.
May I have two points to that quickly, because I know I'm almost out of time. First of all, if you look at the insurance statute, which I think is 34, they specifically talk about public and private way. So my feeling is if they wanted to exclude, they would have excluded rather than include, which they did include at the beginning of 24(2)(a) with the public way language. But to your point, Chief Justice Gantz, this is not a great statute. And I think the fact that you have a split in appeals court panels, you have jury instructions, which I understand are not, the end-all and be-all, but they're used every day by practitioners and by judges to set forth the elements. The jury instructions in 213 say public way. And I would point out, I didn't have a chance to do a 16L, but the new jury instructions that came out, I think, 2 months ago, include still public way in leaving the scene of property damage. So you've got a split in the authority, persuasive as it may be. You have an appeals court decision in this case, which really doesn't address the issue. You've got jury instructions that say you need a public way. To me, this is a case that no regular person is going to be able to understand this statute and understand what they're not allowed to do. And therefore, I would ask the court, I guess my strongest argument is to ask the court, under the doctrine of lenity, to please vacate Mr. LeBlanc's conviction under this statute, because this statute is clearly ambiguous. It cannot be really read in harmony without doing a lot of gymnastics, which my brother very nicely pointed out I do, and vacate this conviction. Thank you. Is there anything further?
All right, thank you.
Thank you very much.
May it please the court, Thomas Townsend for the Commonwealth. Gymnastics are only necessary if we adopt the defendant's construction of the statute. Under the Commonwealth, and I submit the plain meaning of the statute, the public way only attaches to the first whoever.
Can I ask you a question, though, about your interpretation? Does that mean that if I have a very large number of acres and I have a son who not only is 17, or 18, doesn't matter, but he's a pretty terrible driver and also not exactly the most forthcoming person in the world. If he were to, on my property, never hit a public way, run into something, he could be charged with a crime?
If he runs into something,
And damages the property and then splits.
And splits.
Splits, yeah. He
Well,
could be charged with a crime?
if we assume that he would be required in that instance to report to you and provide his name, address, and license number, potentially yes, he would be under the plain meaning of the statute.
Well, that's where I'm having trouble. I guess I appreciate the fact that the appeals court is hard to, but it just seems to me, at some point in this saga, the person has to have driven on a public way.
Well, if we look at use without authority, which is also within this statute, it's the eighth whoever. Under use without authority, I specifically point to the appeals court's decision in Morris M. That's where someone took control of a Jeep and rode through a golf driving range. And the appeals court held that there's no public way that attaches to use without authority under the statute. And in that instance, which I submit is similar to Your Honor's hypothetical, yes, you could be charged. What the legislature sought to do is to allow owners of property to identify people who cause damage to it, regardless of where it happens, if the other person caused it with a motor vehicle while operating a motor vehicle. If we look at through the other whoever's, the second through the eighth whoever, not all of them, there's only one actually that through implication has a public way element, and that is the teen cell phone use. And we only know that has that if we go and look at Section 8M.
Well, 8M, I think it's also true of 12, whatever it is.
No, 12A does not have a public way element, and 13B does not have a public way element. And that was intentional by the legislature. When the House was considering 8M, the original version of the statute had a public way element. Representative Provost filed an amendment to strike that provision, bringing it in line with the other provisions they're considering. The House adopted that. So public way was once in it. It was removed from 8M, but then in conference committee with the Senate, it was reinserted. So the legislature was cognizant of what they were doing in 12A and 13B. And 12A and 13B specifically do not have a public way element, whereas 12A does. 8M does. And we must presume that the legislature intended the difference, especially when we're considering it was part of the same legislative package, and it was specifically addressed in conference committee by the legislature. But I want to step back and let's assume, for instance, that, taking my sister's position, public way does attach to numbers 4 through 5, having to do with license and learner's permit. How is a judge supposed to instruct the jury on the public way element? If someone is lying on their learner's permit, how does public way come in? How is the Commonwealth supposed to satisfy that element? Present evidence that the young person was walking across the street while he was filling out the application, put a false statement. It doesn't make any sense. If not everyone loans a driver's license so someone else can drive. Driver's licenses can be used for underage alcohol purchases. And I think that is part of what's intended by the legislature here. There's no public way element for that. Similarly, if someone does a false statement in application for registration of motor vehicle, there's no public way element available for that. But under the defendant's construction of the statute, the public way element, which is only included with the first whoever, would have to apply to each of these separate offenses. And the only court to address this issue was the appeals court in the Brazzi case, which was an unpublished decision. And they dealt with it head on, and they said the only clear reading of the statute, so that it's not absurd, is if the public way attaches to the first one and not to the successive offenses that are listed. Some things have nothing to do with public way. But the legislature included them here, presumably because the penalty they intended was the same. But if we look at whoever as demarking separate offenses, then the statute can be read sensibly, I submit.
So can I just get clarity? When you answered Justice Botsford's question about the teenage son driving on private property, hitting something that belongs to someone else, for example, I don't know, someone's golf cart that happens to be on the private property, and then leaves, you're saying that that gives rise to criminal liability for leaving the scene of an accident causing property damage?
Correct, just as it would in the Morris M. case if the defendant there had been charged not with unauthorized use,
Well, that's
but with leaving the scene.
So you're saying that unauthorized use is the same as, in the same posture as leaving the scene of an accident causing property damage?
That is my argument. Now, I recognize that there's a semicolon before unauthorized use.
Yes.
But the semicolon there, I submit, is because there's a distinct penalty different from its predecessors that warrants the semicolon.
A different crime.
It is a different crime, as I think all of these can be read as different crimes, and that's my argument. There's 8 different crimes here, and only for the first. And interestingly, the first whoever doesn't just have a single prohibition. It prohibits driving recklessly, it prohibits driving negligently, it prohibits driving upon a bet or wager in a race. That's the only one that has a grouping, other than if we drop down to number 7, which references 8M, 12A, and 13B. Everything else is a single prohibition. I think that lends credence to the Commonwealth's argument that public way attaches only to that first group following the first whoever.
And what is the significance, if any, of the change in statute in 1971? Of this statute, of the revision?
That's separating the 8A.5 from the.
I mean, I gather that at one point in time, there was a requirement of a public right-of-way for this crime, correct?
That has never been specifically addressed by an appellate court. The only court to address this issue of whether public way attaches to leaving the scene of property damage was the Brazzi decision in 2008.
Yeah, but I thought I thought there had been a revision of the statutory language.
There's been very many revisions.
To this piece of it. This,
There's been several revisions to this piece of the statute.
Wasn't it clear before the 91 amendment, I think it is, that public way was correctly written in without any difficulty scrutinizing the whoever's?
I don't think that is accurate. I think if we're dealing with this portion of this statute, the leaving the scene of property damage, that's never been raised specifically before. A.5, I recognize, presents an anomalous situation where you have a public way element for leaving the scene of personal injury. Now, the analogy that I thought of was the home invasion statute not too long ago, where if you committed a home invasion under the statute using a weapon, that was a life felony. But if that weapon was a gun, it wasn't a life felony. And this court was presented with that anomaly, and this court recognized it is anomalous. The legislature may not have intended that, but the statute's otherwise clear, and this court needs to read it accordingly. And then the legislature went and fixed it. I think the same thing could happen here, where this court could point out, perhaps the legislature did not recognize what had happened, that there's public way element for leaving the scene of personal injury, but not leaving the scene of property damage. And the legislature can either add a public way element to the property damage or remove the public way element for personal injury, thereby bringing it incongruence.
And what do we do with regard to the rule of lenity and the fact that our jury instructions, or at least the district court jury instructions, seem to have followed the footnote in Platt and have made it an element of the crime? Is it unfair to change the law retroactively? Should we simply say, going forward, this is now the law, but it doesn't apply until we say so?
Well, I think model jury instructions are not always accurate. I believe the appeals court decision last week noted that in one of the jury instructions. It's unclear the chicken or the egg, where did the model jury instructions come first in this court, copy of the model instructions, or more likely the model instructions followed the court's footnote in Platt, which I suggest just transposed the elements from personal injury onto the elements for property damage. There was no citation in that footnote. It was dicta. It was not an issue in that case. The rule of lenity only comes in effect if there's ambiguity. And I suggest there's nothing ambiguous about the statute.
Well, would you include as an element of ambiguity or an indication of ambiguity the fact that the cases have all seemed to come down on the side of public way? I mean, wouldn't a defendant, to the extent that anybody is on notice of what the statute provides, be thinking, I'm good as long as I'm not on a public way?
Well, all those cases that listed it as an element, there's 3 in the appeals court and this court's decision in Platt. That was all dicta. It was never raised.
No, I understand, but, as far as we're talking about notice and ambiguity, I mean, the average person on the street is not going to understand the difference between dicta and holding in the case.
I believe that's the distinction that this court has drawn when we deal with notice. People are presumed to know that the portions of a statute, the statutory language, and opinions of this court and the appeals court interpreting the statutory language. There's only one court that has interpreted this statutory language in this context, and it was the appeals court in a published decision in Brazzi. Everything else is dicta. I don't think a person could make a successful argument saying, well, I was relying on dicta in a case. The defendant in this case did not raise this issue initially in the appeals court. It was only when my sister was in Belchertown District Court and there was a case that was dismissed with similar facts. There was a driveway collision. And I got the call saying what had happened, and we both had agreed to, well, let's get this issue in front of a court because I didn't think that was right, and she wanted to include it, obviously, for the benefit of her client, and that's how this court case came up here. But it was not something that the defendant was relying on. He made no argument that he thought he was in a driveway and therefore he was free of the crime. His argument was that he thought that the person who he was with, Mr. McCarthy, was the true owner of the automobile, and he already knew his identifying information, and thereby he didn't have to tell the true owner. And the judge, rightfully in our opinion, rejected that and found that he had collided with the mother-in-law's car and left the scene.
So what does that have to do with lenity? I'm missing the connection there.
Well, to the extent that the defendant, well, I think there were 2 issues. There was one with lenity and one with notice. And as far as notice goes, the defendant never made a claim that he was relying on dicta from this court when he left the driveway that day.
So notice goes to what?
Well, I think notice would go to a due process claim, which wasn't raised in this case.
Okay.
We're dealing with strict required finding.
Your explanation of what happened below has nothing to do with the lenity piece.
No, lenity would be, and my argument with lenity is lenity only, the rule of lenity only attaches to the extent that a statute is ambiguous.
Can I ask you an unrelated factual question? How did the damage on the defendant's truck happen in the front of the truck if the injury to the mother-in-law's car was by backing up?
Well, her car was at the top of the driveway facing out.
Didn't he back in both times?
That was his testimony. It may have been Mr. McCarthy's testimony as well, but he had told the officer that he had skidded on the snow as he was pulling in, and there was damage on his front right end.
So the theory is that he did, at least one of these 2 times, he went front ways.
He did go front ways on the initial trip there. And in fact, Judge Ross, in finding the defendant guilty, credited that that's what had happened. He didn't back in the initial time. He went in the initial time. He backed in the second time, presumably to hide the whatever damage there was, or try to get Mr. McCarthy to leave the car without noticing the damage. Unless there's further inquiry from
Yeah,
the
I don't want
court.
to take any time of yours, but just out of curiosity, since I do drive every day, whoever operates a motor vehicle for the purpose of making a record, what should I be careful about?
I had to look into that. That's goes back to the advent of the motor vehicle and is a record for speeding. Section 17, Section 18 both have to do with speeding.
And
So
what's
it's
the record? So the purpose, so I should not drive for the purpose of making a speeding record?
Going to try to make a speeding record,
That's good to know.
whether it's on a public way or not.
Okay, thank you.